All right, good afternoon, everyone. I'm Ann Massey Badmus, and I'd like to welcome you to our educational service of a webinar entitled Immigration 2019, a look at the year ahead. Before I start, I always like to make sure that we have any technical difficulties taken care of. So if you can hear and see me, please just type in your chat pane to I believe to the right of your screen, just type yes there. So if you can help me out with that, anyone would just type yes. Great. Great, I'm getting some yeses there. So wonderful. So I'm hopeful that the technology will continue to work, and we will go ahead and get started. So again, welcome. And we're here to help you as employers and international professionals plan for the year ahead and what you might be able to expect. We have a very diverse group of attendees, anywhere from employers and employees from all different industries. So we're not really going to be very specific on any particular application type or particular focus of concerns for any particular industry. What I'm here to do today really is to take some time to answer some of the common questions that we get asked about what's going on in immigration, what can we expect, and some of the things that we are seeing, and to the best of our ability, trying to predict for you, and so that you can be prepared for what you need to do with respect to your applications or your visas or green cards even. So with that, let me go on and introduce myself a little bit further. As I mentioned, for those of you who don't know me, I'm Ann Massey Badmus. I'm an attorney and the immigration partner at the law firm of Sheaf and Stone, which is a nationally recognized law firm located in the Dallas, Texas area. I've helped thousands of clients nationwide with immigration issues, including employment-based visas and green cards for over 25 years, actually. So my team and I work with clients really to help you to manage your immigration cases and be able to get the results that you need in order to either hire employees or, as an employee yourself, continue working and living in the United States. So with that, let's go on to our agenda for today. We're going to talk about really 4 areas of or 4 topics that I think might be of interest to you and may help guide you through this immigration maze that we have out there. So our first topic is we're going to talk about application processing times, and I'm going to kind of go over how you can find out about how things are going in terms of application processing time specifically for your cases, but also just in general what we're seeing out there. Then we're also going to talk about some of the proposed employment visa policy changes that the government is saying will probably happen over the next year or two. And then we'll talk about some of the new policies that we saw back in last year and what impact we expect to affect, or what impact we expect there to be for employment-related immigration cases. And then finally, we'll talk about some of the trends that we're seeing with respect to the USCIS, the United States Citizenship and Immigration Services processing of applications. But most importantly, I really want to leave enough time for everyone, hopefully, to get their questions answered. So along the way, let me just move forward here. Along the way, I would love for you to go ahead and type your questions. We will have a question and answer session at the end of the presentation, and I'm hopeful that we're going to spend about 30 minutes on the presentation and have another 30 minutes to answer any questions that you may have. So please feel free to put in your questions, but make sure you put them into the right place. You have 2 areas that you can give us feedback. One is the chat area, which is what you just filled in to just let me know that there were no technical difficulties. So we want to keep that just for an issue with the webinar in itself. If you're having any kind of technical difficulty, go ahead and use that chat pane. But if you have a specific question that you want to ask about immigration, then you'll scroll down under the screen, screen that you have there, under the presentation slide that you see, and you'll see a section that says questions. So that's where you want to put in your questions. It helps us to keep track of all the questions out there more easily and make sure that we do get your questions answered. So we will possibly answer some questions along the way, but more than likely at the question and answer session, I will try to go through all of the questions that I've received. So make sure you go ahead and put your questions there as we go along. All right, so next we're going to talk, as I mentioned, we want to talk about application processing times. We get this question all the time: how long is the application going to take? And you know, we have been noticing over the past few years a tremendous slowdown in almost every area of immigration in terms of applications. So, you know, whereas in the past, many people have felt that it's been fairly quick. You might get a green card application, at least the adjustment of status phase, completed within, you know, 6 months. Some people were fortunate to have it done in 3 months. But on average, we've seen a lot, you know, a much more increase in that. So what I'm going to do is kind of go through these different types of applications and and show you, first of all, how you can locate what is going on with certain types of applications, and in particular for your own application as well, and then also give you some background on the government shutdown, or right now we're out of the government shutdown, but just kind of give you some background and information about that should that occur again, and its impact on immigration processing times. So the first application process or first government agency that deals mostly with most immigration applications is the USCIS. So that would be the, you know, your typical applications like H-1B, your green card applications, your citizenship applications are all administered by the USCIS. So at this website that I've listed here, the government has somewhat improved their information that they put out there as far as what their expected processing times are. But of course, there are no guarantees of those particular processing times. And what they say is that is really pretty much what they believe are the average processing times. So what I'm going to try to do here is to share my screen and hopefully be able to show you where on the USCIS website you can get this information. So let me see if I can manage that appropriately. Oh my goodness, where am I? Okay. Let's see if I can share that, and hopefully you can see that. So what I'm going to here, and if you cannot see my screen being shared, please put that in the chat pane if there's an issue there. But let me show you what the processing times are. What I want to go to is the USCIS processing times website. And here you can determine what generally the government is doing with respect to processing applications. How much time is it generally taking them to do that? So if you look at this screen, you will see that you can choose the particular form or application that corresponds to your application. So if you have an I-129 non-immigrant worker application pending, that is a typical H-1B and O-1 and some other applications, some other visa types associated with that petition or application. You would put that information in, and then you would determine which service center is handling your application. And you would know that by looking at your receipt notice, which will either indicate CSC for California Service Center, Nebraska Service Center, Texas Service Center. So you will see, you can tell from the receipt number and of course from the address on your receipt where that is. So if we look at what is going on with I-129 applications at the California Service Center, we click on that and ask for get processing times. Let me just see. Sorry, I just wanted to check on one thing here. Then you will see that they give you a table. And if you scroll down, it gives you kind of the different types of applications associated with I-129, and they will give estimated time range. So for example, for an H-1B application, there are various categories of that. If you are applying for someone for an H-1B application where it's a change of status in the U.S., then you can see they're saying anywhere from 9.5 to 12.5 months, which is a tremendous amount of time. It is very, very unusual to see this kind of processing time. But this is the kind of, at least in my experience, over the 25 years that I have worked in immigration, this is probably one of the longest periods of time that an H-1B application would take. So as you can see, the trend is that the government is taking a tremendous amount of time to adjudicate these very important applications here. So as you can see, that is one indicator, or really confirmation of what I was saying as far as the length of time that the government is taking. And we do not see anything really changing with that over the next year. We can still expect to see that kind of lengthy processing time. So just one more point on this. If you are looking at this screen and you're saying, well, my application has been pending 9.5 months, so I should be able to, contact the government and find out what's going on and see if they can, make a decision now, since I'm in a 9.5 months range. Well, what this right column is telling you is that no, you can't. So the only way that you're able to contact the USCIS and get a response or an answer or any movement on that case as a result of your call would be if your receipt date for the application, meaning the date that you filed the application and they issued a receipt, would be January 29th, 2018. So that's more like the year ago. Today's the 30th. So if your application was filed before January 29th, 2018, and you still have not gotten a decision, then you're able to contact the USCIS to ask them what the status is and hopefully move them towards a resolution of your case. So going back to that, so that is one list that I wanted to have you take a look at. The other, oh, I'm sorry, I understand the screen is very small, so it's really difficult to see. So let me see if I think I can expand that. Oh my goodness, it doesn't work like that. Let me try. It doesn't work. Let me see if I can fix this so we can get this screen going a little better than that. So let me see if I can just do. If I can open up another window, let me try that. Okay, let me see if that will work better. Please excuse me, I will get this straightened out so you'll be able to see this much better. Okay. Okay, I think that should work. Okay, so I think this is better. Hopefully you can see this better. Please let me know if it's a better screen. Great. Okay, so I got some yeses here. So the next, so the next screen, and I'm sorry, I can go back to the other one, but let me just proceed with this one as well. So the next screen that I wanted to show you, actually it isn't this one, I'm going to go to the next one that I'm looking at, would be for the labor certification application. So let me put that in. Okay. Okay, let me see if that's going to help us any. Okay, so as you can see, what I have up now is the Department of Labor, Employment and Training Administration processing times. This relates to the labor certification green card applications, those applications that we call PERM, where the first step of the process is to apply to the Department of Labor for their approval of the application. So that PERM process, once it's submitted to the Department of Labor, then it goes into their processing queue. And as you can see here at this website, you can see what their processing times are generally for applications. In this chart where it says NPWC processing times as of the end of December, they are saying for the perm applications, their date that they are actually working on would be August 2018. So you're seeing about a 5-month processing time for the Department of Labor perm applications. And that actually is pretty consistent. That is one area of processing that has not really been inordinately delayed like it has been with the USCIS. So if you are in the perm process, once you apply for the perm with the Department of Labor, then you can expect about a 5-month processing time. The other information here really isn't kind of, well, we don't have time to go over those parts of the process, but essentially I wanted you to see how you can determine and to see also what you can expect for perm processing times over the next year. The other process that I wanted to go over with you, which I originally had up, was the visa bulletin. So you can see here, the visa bulletin is really a control, as what we call the green card waiting list. And for employment applications as well as family applications, but we'll talk about employment applications. So as you can see with the visa bulletin is administered by the Department of State, and they determine when there is a green card available for any particular category of green card application. And in this case, if we go to the visa bulletin for February 2019, which is coming up, we can look at the visa bulletin and determine a couple of things. First of all, we can determine when a green card application can be finally approved, depending on the visa bulletin, and when it can be finally approved, number one. And we can also determine when you can actually apply for the green card or the adjustment of status phase of the green card process. The adjustment of status phase is the last step of any green card process if an individual is legally in the United States and can apply for adjustment of status. So it's very important that if you are applying for a green card as an employer, and as the employee, of course, you know what is going on with the visa bulletin to determine what you can expect in terms of final approval of your green card application. So there have been some changes. Let me backtrack. The visa bulletin is issued on a monthly basis. And it really is kind of hard to predict because we really don't know publicly, if the public really doesn't understand, and I'm sure the Department of State even understands how they calculate or determine when these numbers or this information. So while we might think that, every month we will be moving forward 1 month, that usually is not the case. Oftentimes, the visa bulletin looks like it's staying still. So as an example of that, if we see, for example, this first chart, the final action chart for employment-based preference cases, as you can see here with the visa bulletin, there's actually been some changes that we have not seen in the past as far as certain categories. In the EB1 category, which covers extraordinary ability applications, multinational manager transfer applications, and outstanding professors and researchers applications, all for the green card, there has been a backlog, what we call a backlog created, which basically means there is a waiting list for just about everyone in that there is a waiting list for everyone who is in that category. So how do we determine when you can actually get your green card approved? Here we see that the employment-based category 1, we have in this first column to the right, all chargeability areas. So what that means is any nationals of any country except for China, El Salvador, India, Mexico, Philippines, Vietnam, all the other countries to the right of that column. If you are not from any of the countries to the right of the column, then you would be looking at the all chargeabilities area. And if you've applied for EB1 and have been approved for EB1, but you applied after December 1st, 2017, then you are on this waiting list. You will have to wait until the application, until this date, what we call the cutoff date, has moved to a different, to move to your date. So if your application date was August 1st, 2018, then you are not able to you're not able to actually get an approval of your application until the approval of your adjustment of status application until that date, cutoff date, becomes August 2nd, 2018. So as you can see, that is a change, and we don't know how long this sort of backlog will exist for EB1, but it is there, and it's something that needs to be tracked on a monthly basis if your case is in that category, to see when you can finally get your green card, and in most cases when you can actually submit your adjustment of status application. Other categories have been pretty steady. This EB2 and 3 and some of the other ones are pretty much current. The C that you see in the column just means that there is no waiting list, that if you have been approved for your category of EB2 with your I-140 petition, then you can apply for your adjustment of status, or if you're already in the adjustment of status process, assuming that all the required processing has been done through the USCIS, you can actually be approved for your green card at your interview, for example. As well. So the trend that we're kind of predicting that I do want to talk about is the EB5 category, that there's been some predictions that this category may become backlog for citizens of India, for example. So if you're an Indian citizen who has applied for the fifth non-regional center, the fifth category, which is EB5, this is where you're an investor, then you may find a backlog occurring sometime around this summer. We don't know that for sure, but that may be something that you should be mindful of if you are actually in an application for EB5 and you are a citizen of or born in India as well. So let me get back to here and finalize this part. So let me go back to our presentation, okay? And finally, just want to talk a little bit about the government shutdown. As you all probably know, the shutdown it lasted for over 30 days, starting December, I think 17th or 21st, I believe it's 21st, and has recently ended. However, during the negotiations, they're still continuing negotiations about extending the spending bill, or the spending bill that Congress has to authorize. So basically, February 15th, we should know whether or not there is going to be another shutdown. Hopefully there will not be. But we've received many questions during the shutdown about how does this affect my immigration case, which is pending now with the USCIS or any other government agency. So fortunately, at least with the USCIS, since it is not funded by taxpayer dollars, it is not dependent upon the spending bill by Congress. So usually for shutdowns, as was the case in this past shutdown, the USCIS continues to operate fully because they are funded by the fees that you pay to process your applications. So we have not seen that as a result of a shutdown, that the slow processing times that were already in existence have slowed down any more than they normally have. So thank goodness for that. And hopefully that will remain the case if there is another shutdown as well. However, for one category, for the EB5 regional center applications, the shutdown is affected. That would be affected by the shutdown. Because of the fact that it has to be reauthorized through Congress, and they usually reauthorize that through those spending bills. So the last time that we had the shutdown, while the government was accepting applications for EB5 regional center applicants, they were not really processing them. They were on hold. So there was somewhat of a delay with respect to those applications. Now, those are the ones only for regional center related EB-5 programs. They are not for what we call direct investment, where an investor is actually starting their own business and using that business to qualify for EB-5. All right. Next, kind of related to the USCIS applications is the premium processing program. And most of you probably know that there has been an option for about 10, 15 years now for premium processing, where you can pay additional money to the government to have them process your applications within a 15-day time period. And in general, premium processing is available for many worker or H-1B or other applications related to temporary visas for work. And usually they're also available for most green card I-140 petitions that go through the USCIS. So that is a real advantage that if you do have, for example, an I-140 petition that qualifies for premium processing and your application has been pending for a really long time and you're frustrated and would like to get that moved along, then really many times your only option would be to pay that additional fee, which is $1,410 at this point, $1,410, and go ahead and pay that fee so that your application can now be processed within that 15 days. For H-1B applications, we've seen this several times. It happened last year as well. H-1B premium processing has been suspended for most H-1B applications, except for certain applications such as the CAP exempt petitioner applications. Those are applications by organizations that are nonprofit teaching affiliated organizations such as universities, nonprofit hospitals that have training programs. Petitioners like that can use premium processing. So as long as you can prove that you're eligible, that you are a CAP exempt petitioner, then you can, a CAP exempt employer, then you can apply for premium processing. If you are in H-1B status with your current employer and want to extend your H-1B status with that same employer, then you can also get premium processing as well. And then as of Monday, the 2018 H-1B cases that were filed last April, which, believe it or not, are still processing, many are still processing. If you are in that category where you filed an H-1B CAP visa application back in April 2018 and you still have not gotten a decision or activity on your case, you can now pay the premium processing fee to now have the government pay attention to your case and start that processing for the case. However, we're also expecting from the announcement back in August last year, that hopefully the suspension of H-1B premium processing will be lifted so that all H-1B cases will have the ability to premium process after February 19, 2019. So we're still expecting that to happen. However, it can be, the government can always change its mind and decide not to do that. So keep an eye out for that. Next, just want to talk briefly about the proposed employment visa policy changes. Again, these are proposed changes, meaning that they have not been made into law. They have not been made into actual policy. They're not being implemented in any way at this point. But we do need to keep a lookout for that because we expect to see something happen in these areas. So the H-1B CAP lottery process, many of you have probably heard that the government is proposing some changes to the H-1B CAP process as to how H-1B visas will be submitted for the H-1B lottery selection and how they will be selected. So briefly, the government at the end of last year, or in December of 2018, proposed a rule where they will have a registration process for H-1B CAP petitions. The H-1B visa CAP process starts April 1st of every year. So I doubt that it will happen this year because there just really would be not much time to implement this process. But the way that it's being proposed is that employers will need to register for consideration of their H-1B cap petitions online. So the government's going to set up an online process for registration of an employer and their employee that they expect to petition for. Once that registration is in, they will basically do a selection based on the registration. And if your registration or your number is picked, then you will be able to submit the actual H-1B petition to the government by mail. That's one change. The other change that they're proposing is how they will end up selecting those registrations for consideration would be that they're first, right now, the current selection, or in the past, the selection process was that they would pick the master's cap, the 20,000 master's cap applications first. And so if you were a master's candidate, a master's cap candidate, and you applied based on the master's cap, then they would actually apply for, then they would pick out of that master's cap first, and then if they were out of all master's cap slots, then they would go next to the general regular H-1B cap slots where you'd be considered along with bachelor's degree candidates. So what they're saying now is that they're going to start with the regular process first, where they're going to pick out of the regular cap first. So if you're in a master, if you have a master's, you will be considered in the regular cap. And then once the regular cap is filled, they're going to now look at the master's cap. And it's their idea that in doing this, this will increase the number of people who will be selected who have master's degrees, which is sort of their objective at that point. But again, this is a proposal. The period for comment has been closed. We may be getting some more information about this in the next month or two. So please, keep posted onto my blog to see if any changes come up. The next area they want to talk about briefly is there is a proposed bill in Congress where the sponsors of that bill are proposing to increase the cap to 195,000 visas, which was the way it was over almost 15 years ago. And they're also talking about removing the country limits on the employment-based green card. So what we were talking about earlier with the visa bulletin, if this bill becomes law, it could actually speed up many people's green card approvals because there would not be that waiting list that we're seeing so much now. So this, again, is a proposal. If is something that as employers or individuals that you would like to see happen, turn into law, then this would be a good idea to contact your congressional representative or your senator to let them know that you're in favor of this I-squared bill. And the last policy, visa policy change that we're expecting, and we've been expecting since 2017 because the government has been saying that they're going to do this. But again, we've not yet seen it happen, but we do still expect a proposed withdrawal of the H-4 EAD. So those H-4 spouses who were able and eligible to get EADs based on this H-4 EAD rule may see that the rule will be withdrawn, meaning that we can no longer, the H-4 EAD will no longer be available, at least as a continuing process. We don't know how that withdrawal will take place. So, for example, it could be that the withdrawal will be that we no longer will take new H-4 EAD applications, but if you are already have an H-4 EAD, we might continue to allow you to extend that H-4 EAD. Now that's just something that I think might happen. I don't know, so we won't know for sure until we actually receive the actual proposal that the government issues. So again, we're looking to see that, and we probably will, it's hard to tell, but we'll probably think we're going to see it sometime this spring. So for questions, just a reminder for those who may not have been in on earlier, if you want to type a question in, please put that into the question and answer pane, which is at the bottom of your, or underneath your presentation slide. So please put your questions there. So next to last area that I want to discuss is the impact of some of the new policies that happened last year. So last year there were, and there are a lot of new policies, but I'm just, in the interest of time, I'm only focusing on a few of them. So the ones that I wanted to mention was the 2018 policy of the notice to appear policy. This policy basically stated that if an application, a visa application, either a green card or even a visa application, like a work visa application, potentially could, if that application was denied and the individual would no longer have legal status as a result of that application denial, that that individual could be referred to or could receive a notice to appear. A notice to appear is a notice stating that you are now in deportation or removal proceedings and you have to defend yourself before an immigration judge. So it is a very involved process. It is the deportation process that we hear about in the news all the time. So pretty much this policy scared a lot of people because it seemed to apply very broadly to almost any application. However, the government has so far stated that it does not apply to employment-based visa petitions like the H-1B petition, for example. So as of this point, it's probably not going to have an impact on you or anyone in this situation if they're an employment-based visa petition. However, that may change in the future. The policy that probably has more of an impact, and we'll see more of what might happen this year about that, is the request for evidence policy. Request for evidence is a mechanism where the government, in the processing of an application, asks questions. So they send a request for evidence saying, oh, we don't see this information in support of your application. Here's your opportunity to provide that information. What the request for evidence policy stated last year is that, well, in the past, that was the procedure, was that if the information was not there, the officer should and were directed to issue a request for evidence. The change in the request for evidence policy was that if the evidence, initial evidence that was absolutely required, or they believed was absolutely required for the application, was missing, that an RFE was not necessary, the officer can, rather than issue an RFE, can go ahead and deny the application and not give the applicant any opportunity to provide that missing information. So that is a policy that tells us that we have to be extremely careful to, as we always have, but in particular in this environment, we must be extremely careful to provide all the information necessary, even if it seems onerous and difficult and time consuming. If it's determined by your attorney that this information is absolutely necessary, even though we might not like it, we need to go ahead and try to provide that information, because it could, without it, in some case, it could be that your application is denied without any opportunity for a second chance to provide that information. So kind of related to that is the trends that we're seeing with the USCIS as far as their applications. According to some of the data that we found, or some reports that were issued, we've seen in the past 2 years about a 200% increase in these RFEs. So even though there's an RFE policy that came out that says we're going to try to decrease the RFEs, before that policy happened, and I think continuing till today, we are still seeing more and more RFEs being issued there. So even in cases where we believe that all the evidence has been submitted, but for some reason the government still wants, in many cases, evidence that really isn't necessarily required under the rules, but we're seeing that the officers looking at these cases are finding objections or some things that they want to see in the application. So that's one of the things that we're seeing as a trend there. We're also seeing as a trend an increase in the denials of applications, a 41% increase. I don't have the data as to what types of applications, but suffice it to say that there is sort of a view of the government that they're looking for ways to, in my opinion, they're looking for ways to deny applications. So again, it's very, very important to have all your ducks in a row, have all the information, and be able to support your case as much as possible. All right, so last thing I'll talk about before I go on to questions would be to plan your visa application, considering the things that I've talked about today and what we expect to see. You definitely want to be sure to, if you're planning to apply, whether it's for a green card, an H-1B, extension, change of employer, any application, if you're eligible to apply as early as possible, because your processing times, as we mentioned, especially with USCIS applications, is incredibly long. So, and in some cases, you might not be eligible for the premium processing. So be sure to plan to do that. As we talked about with the possibility of denials based on the RFE policy, as well as the increase in denials, you want to make sure you document your applications extensively. Some of the things that we're seeing, especially for H-1B applications, we might want to have, especially for some occupations, in particular in the IT industry and occupations that aren't what the government automatically considers to be specialty occupations. So, for example, if you are a physician, you don't need to worry about proving that's a specialty occupation. If you're a lawyer, you don't have to worry about that. If you're a teacher, an architect, or an engineer, those are the 5 categories that in the law specifically states these are considered to be specialty occupations. But if you're not in one of those categories, you have to prove that you and your employer have to prove that position that you have is eligible for H-1B as a specialty occupation. And that's where you might need to provide expert witness reports. The employer might have to provide proof of work product. I mean, what do you do on a daily basis? What kind of reports do you generate? What is it that you specifically do? And provide much detail as to your daily duties for the government to agree that, yes, this is a complex position requiring your education and background, or extensive education and background to perform the duties. And then for employers and individuals as well, be prepared for higher cost due to the RFEs that we're seeing and the extensive production of evidence that's going out there. Finally, if there is a denial, what we are seeing is a trend, which I didn't list here, but more and more people are actually turning to the courts. We often hear a lot of cases out there, not necessarily related to employment-based visas, but things like TPS, DACA, the border wall, different things, the border issues. We see that there's a lot of litigation going on against the government because of its policies, but not so much publicized in the news. There are more and more employers and individuals filing lawsuits, and in many cases winning their lawsuits with respect to denials of the visa application. So a denial doesn't necessarily mean it's the end of the process. There are ways in many times to either move to reopen it, to appeal it, and ultimately to sue on it. So keep that in mind as well. So I want to go ahead and start with the questions. I went a little bit more than I thought, and I do apologize for that, but hopefully it was helpful. So I have a few questions here, and I'm going to go through each question now. If you have questions, again, go ahead and start putting those into the Q&A question pane below your presentation slide. I'm going to answer as many as I can in the next 15 minutes, but I would like to give everyone a chance. So please, 1 question per person, and then be sure that you understand that if your question really is more specific to your case, I may advise that you contact us for a private advice session, because this is a public forum and it's not really appropriate to talk about individual cases unless I can make it a very general response to it. So the first the first question I have is that someone's asking about a EB-5 filing, which is the I-129, which is the second part of the second step of the application, where it looks like they were initially approved for the EB-5 and now are asking for removal of conditions. So you're asking about the processing time is still true. Now that, again, would have to go back to the screen that I mentioned before, the USCIS processing times, to see if it is true that it's a 2 to 4 week processing time. The question also was, upon receipt notice, what are working limitations? Can I continue working? Yes, if you are actually already applying for your removal of conditions, your green card is still continuing to be effective and you can continue to work. You can also continue to travel as well. So for finding out whether your processing time is correct, go to uscis.gov. Check the first on the screen there will be a area where you can click on case processing times. And you click on that and you put in the application where it is, find the application type, find what service center is processing it, and then you can see what their expected processing times are publicized on the site. The next question is a question regarding physicians working in a health professional shortage area, MUA, and talking about renewals. So I'm not quite sure what it says, would this affect, and I'm not sure what we're talking about with this. I think this question, if you could clarify, please, and just let me know what, just put in the question and answer pane what you mean by that first question of what would affect physicians working in a health professional or MUA area. If you could talk about that as well, put that in there. But the next question you also ask is, how do I see EB1 retrogression for Indian applicants? Is it likely to have some permanent retrogression? That's a good question. This is probably a very recent trend, starting last year, seeing this type of retrogression. It's still, EB1 is not an easy category to qualify for, although we're seeing more and more people getting approved. But I don't see that because of the difficulty of getting qualified. I don't see it as a situation where there would be a sort of a permanent retrogression like there is for the EB2 category. So this is why one of the reasons why it's really important for employers and individuals, even if you're not a U.S. citizen, but you have family members who are U.S. citizens, to ask them to contact their congressional representative and say, we really need to get this system fixed as far as these long delays for people to get their green cards after working many, many, many years here. Next question is, what is the present process time for CAP exempted applications? Because there's no differentiation on the chart that we talked about at the USCIS. And that's true, they don't have that as that, because basically the fact that you're CAP exempted, and I'm assuming there's different types of CAP exemptions, but if assuming you're CAP exempt because of your employer being a university or a university affiliated nonprofit organization, then they're not going to show any difference in terms of application timing. It's not, they don't take you out of the queue because of you being in that particular situation. So the only advantage that you have in that kind of situation is to actually be able now to apply for premium processing in order to get your application decided faster. But you're not going to be any different than the other applications that are there for a change of employer or an extension of employer situation, or a new H-1B CAP application. Next question is, if your application is denied based on a request for evidence, what are your options? Do you appeal? Do you start all over? Basically what you do. It's a good question. So essentially, as I mentioned earlier, there are options depending on what the reason is for denial. So you have to always, of course, look at, is there a way for me to even overcome the evidence, or to provide what they're saying I lacked in terms as a result of the denial. So if you feel like either they were wrong in the decision because they didn't apply the law correctly, or they didn't understand the evidence correctly, or a number of reasons, but you believe that you can justify your application, then you do have several options. You could do a motion to reopen. However, that motion has to be done usually within 30 days of the denial. So you have to make a quick decision to do that. Motion to reopen basically means that you will go you will pay the fee for a motion to reopen and ask them to reconsider your application. It's not a new application, it's a reconsideration of your denied application. And sometimes that does work. You can provide additional evidence, you can provide more information, you can provide legal argument in a motion to reopen, and it might persuade the officer to change their mind and approve your application. So that's one option. You could appeal the denial, and so an appeal of the denial also has to be done typically within 30 days of the denial. And when you appeal the denial, you have to explain why you believe the decision was incorrect. You file that, pay the fee, and then it'll eventually go to the Washington, D.C. appeals unit. Appeals on average are more likely not approved. So in the sense that what I mean by that is that the government generally does not overturn a decision that an officer makes. Most of the time they will still agree with whatever the officer stated, and sometimes they will even find another reason to deny your application that maybe the officer didn't see. So appeals usually aren't the best way. Sometimes it is worthwhile to do it, but that's something that your attorney should really determine. You can start all over again, which was one of the other options I mentioned, which is to actually file another application, pay the fees for that, and try to provide more evidence that will hopefully get your application approved. And that we've done in the past as well. And just because you had an application that was previously denied, it does not mean that the new application would also be denied. So sometimes that would be a good option. And then, as I mentioned before, some employers some people are actually going to sue the government. Now, that is a much more expensive and difficult process, but depending on how important it is, then you may consider that as well. All right, a few more minutes to answer. Sorry, it's trying to find the questions here. Okay, so the new H-1B rules, to getting back to the previous question, thank you for clarifying that. So with the new H-1B rules, how would new applicants, I hope everybody's here. I'm hoping everyone can hear me. Is everyone still there? Because I'm getting some notice here. All right. Great. Thank you so much for letting me know. Just technology. Great. So the question was, if new applicants or H-1B renewal applications for physicians and HPSA or MUA apply for H-1B, would the new H-1B rules affect them? The question you're hearing about physicians in private practice having their H-1B applications rejected. So the new H-1B rules that I referred to really are for H-1B cap cases. So it's I doubt that those would. It's hard to say what will happen with that. So if you're a physician getting a brand new H-1B and you are subject to the H-1B cap, then those new rules might apply to you once they're implemented, because that's just a way of them deciding which applications they will accept for further processing. So it's hard to, whether you're a physician or any other occupation, it's really going to be difficult to know whether that will that probably will not have any effect any differently than the way they're doing things right now. However, as far as renewals, and I'm not sure where people are having their H-1B rejected, but if you're renewing your H-1B application, then really you're not going to be affected by the cap registration rules. You're just basically going to go into the process. And for H-1B renewals, typically with the same employer, you can pay for premium processing to have that done fairly quickly. If you're changing employers, you may find that you won't get a decision on that for quite some time. However, with the portability rules, you are able to change employment even though your H-1B application has not yet been approved. So I'm not sure if I handled all, said that all was what we're looking for, but I see there's a comment, so just to be sure. All right, so there's, okay, so the other, let's see, there's another question here. Trying to keep track with that. Sure. All right, so hopefully that's answered. Then someone else is asking you asking about the content for reviewing, yes, we will have a recording. So you'll receive a recording after this event. So and it's unlimited views. So you will have as much time as you need to review that. So thanks for asking that. Someone asked, is there any hope for someone who has had an adjustment of status application denied and it's been more than 1 month since the appeal period? So in that case, it depends on the specific situation. So it's a very broad question. It's very hard to answer because it really does have to depend on each person's individual circumstance on that. All right, and then there is one last question I think we have time for, unless someone else has anything else. Is there a significant chance of denial of application after I-485 interview? If so, what recourse do you have? And so as far as denials, it really, again, it's the same sort of thing. It depends on individual circumstances. So most I-485 applications are approved, after the interview. The denials really, again, are either going to be something related to your immigration history or your employment history, some things that they might find about your individual circumstances. It could be something specific about, it's very difficult to say. So I would not say there's a significant chance of a denial. There's always a chance of denial, but that's just based on the fact that each individual has their own unique circumstance, and there may be something in your circumstances that might warrant a denial. An I-485 application is a green card application, and even if you are married to a U.S. citizen, there's still a possibility of denial if you are what's called inadmissible. Inadmissible means that you must have done something in violation of the immigration rules that despite the fact that you qualify in every other way, you are still not eligible. So for example, if you violated your immigration status, like an H-1B status, and you did not comply with the rules there, or student status, for example, that could be a basis for inadmissibility. I'm not saying it always will be, but that could be a basis. So again, it really just depends on your circumstances. All right. So I believe that's in the questions. Just before we go, I just wanted to emphasize to everyone that this information was provided as a service, general information, as I've kind of said several times. Each case is different, so it really is important that you consult with an immigration attorney specifically for your specific situation so that you can get the right advice. Because again, everyone really is unique. Even though you may seem like your application is like everyone else's, it is unique. And so you need to be sure that the advice that you're getting and information that you're getting does really apply to you so that you can plot the right course through this immigration process. If you have any other questions and need more information or advice, please feel free to contact me. My number and email address, as well as my blog sites, websites, where you can get updates between these webinars as to what's going on. So I'm trying to update as quickly as possible and give more information about different things that are happening in immigration law. So please go to my websites and follow me, or check back periodically so that you'll be able to get that updated information. We also have a newsletter that we send out on a monthly basis, which has some updates as well. So be on the lookout for that so that you can stay as updated as possible and help you in your immigration planning as well. So again, thank you so much. Appreciate it, and I wish all of you a wonderful day and a great afternoon. Thank you.